Today we're going to be talking about contract law as it relates to financial planners. I think a lot of you think that when we talk about law, we're talking about securities law and insurance law, and probably that's about it. And yet that's such a small part of the legal areas that you have to be involved in as a financial planning practitioner. We've covered a lot of the events so far, like employment law, insurance, etc. But I think this one you'll find be a little bit different because we're going to be talking about the contracts and the type of contracts you run into. Now, when you took business law in high school or college, you probably studied the Uniform Commercial Code because that deals with products, and that's where most of the problem areas are. We will not be covering that really. We're going to be covering the service contracts, which have different laws. And the interesting thing is that a lot of the aspects of the service laws we talk about go back hundreds of years. This is not anything new. It's not even evolutionary. It just really hasn't changed a lot. And so some of the things may seem a little archaic to you because the formality is so great. But again, that's the laws we have to live with. So let's get started. First of all, our objectives. At the end of this module, you should be able to identify the major elements of a service contract, discuss the basic requirements of a service contract, describe the remedies for breach of the contract, and finally understand the use of arbitration. And arbitration, believe me, is a big help these days with clients and with suppliers. We're going to start with talking about contracting in general. One of the more confusing areas of this course is contracting issues. This is especially for those of you who cover 2 or more states, and each state again has different laws and interpretations of what the laws are. Even such things as trust law, probate law, and Uniform Commercial Code, which most people think are the same. You go state to state, they're different. And therefore, those of you who work in multiple states, such as in the tri-state area, you're going to find a lot of problems just understanding the rules as they apply to you. And again, you really need to have legal support in these areas. For those of you who are in, say, Southern California, you have your big enough market, you don't really go anyplace else or need not. You still have to figure out what the California interpretation is. And again, depending on what court you are in, California may also give different interpretations. I remember you have a number of different contracting forms. There's contracts for insurance, there's contracts for real estate, securities, services, purchase of goods, etc. And we're going to stick primarily with the services one in this course. First of all, let's talk about some boilerplate contracts. Many use the standard contract template designed by a lawyer for the state for servicing contracts such as with clients, and that might be called a client agreement or client confidentiality agreement, or it might be just called an agreement or contract. Contract sounds a little formal, and I think agreement sounds a lot better, or memorandum of understanding sounds good. Again, it's the wording that's important, not the title, but many times people get scared by titles, especially when they see the word contract. And so I suggest using other words. Just as there's no 2 clients are the same, it could be true of the consulting contractor clients. I personally believe that we need to tailor a lot of parts of the contracts or agreements we have with our clients for their particular needs. When we put a boilerplate in, it really doesn't work. For example, if I'm dealing with a young couple, 22 years old, unmarried, but living together, and they want to have some agreements, is a lot different than a retired man, 70 years old, who's trying to decide what to do with the assets that he accumulated during his life. And it would also be different if I was dealing with a former wife who's got 5 kids and nobody's providing child support. Again, all of these have different needs, and I try to tailor my contracts for them. And also realize that when we talk about boilerplate contracts, Many of your clients will read the agreement, and if they read it, they'll probably want changes. That's especially true if you get engineers for your client, and sometimes other scientists too, but especially engineers are very much into changes. So my basic philosophy is comes in, and either the parties or both the parties are in STEM work, science, technology, engineering, math. I realize that probably going to have a discussion on what the terms of my agreement says. And a lot of times I say, well, that's really required by state law, or that's required by financial planning board. Those are true statements in many cases. Also remember that terms of contract that are subject to interpretation are interpreted against the writer. And you being the writer, if there is a misinterpretation, it's going to be against you. So even though I do modify the things, I try to get the information for modifications from a lawyer who's familiar with service contracts in the states where I'm working, which right now is in California. Some common law civil code contracts are what we typically use for service contracts in the United States. Again, if you have an insurance contract you're filling out, there's special rules for that. There's special rules for a lot of specialties, and depending what state you're in, we're going to use the generic historical common law contracts in our discussion. And that's sort of being generic is probably the best way, because if I try covering, say, state of California or state of New York or something, it doesn't apply to everybody, so we're being very generic. Main thing is you get the point of why you got to see an attorney and why your attorney should be involved in writing your documents. I've, in my due diligence with financial planners before I became a financial planner, I had visited 10. 3 of them obviously wrote their own agreements. I mean, I could just tell by the way they were written. The other 7 were very professional, and quite honest, the professional ones I felt more comfortable with, knowing that they were very clear as to the intent. Where on the 3 that were written by the practitioner, or maybe the brother-in-law, someone who didn't know the law, I felt like uncomfortable as to what they were trying to achieve in some cases. So especially one was 3 pages long for a client, and I said, my God, who would really expect a client to read a 3-page contract? Most states, as I mentioned, use common law contracting for services, and when you deal with common law, procedure is very important, and these procedures have not changed in hundreds of years. And if we're buying supplies rather than buying under commercial code, in those cases substance becomes important, and the procedures kind of go out the window. But for purposes of service contracts, much of your contract is going to be, from a legal standpoint, a template. What isn't the template is your statement of work, exactly what you and your client are going to do with each other. But there's a lot of formalities you have to do procedurally, make sure that you have a valid contract with your client. Although there are differences and basics exist that are covered in the following slides, and that's what we're going to emphasize. A summary of the most civil code requirements. First of all, formality of contract, capacity, formalities and statutes of fraud, terms and conditions, third parties, performance, defenses, disputes, and remedies. Again, these all are associated with what we generally call common law of contracting, and very common in states. Again, some courts interpret a little bit differently, but for the level we're at, this should be adequate for most of you, if not all of you. First of all, the formation of contract, there must be a clear offer and an unconditional acceptance of the offer to have a contract. So I must use the words I offer, I propose, and your answer is I accept. I don't say I accept if, and I don't say, well, maybe I accept. It's got to be unconditional, I accept. And the best thing is to just have the words I accept or acceptance at the bottom of the contract. As soon as you put anything other than the word acceptance, that's considered a counteroffer. And in some cases, it's referred to the need for a mirror image. In other words, a mirror image is what I say you have to agree 100% with. Any deviation at all, it's not a valid contract. Now, I know some of you say, well, I took UCC, or I took business law in high school or as an undergraduate. Yes, in those cases, you took the UCC, and it doesn't have to be 100% agreement. You can always work it out, but under the formality required of service contracts, it has to be a complete agreement, and the contract can be formed as a bilateral, which is most type of contract, or it can be a unilateral contract, and let's explain what those are. Bilateral contract is one where each party of the contract makes a promise to the other. The contract is promises by both parties. Now that surprised a lot of people. A contract is a promise. That's what it is. I promise and you promise. Where a unilateral contract is when one party makes a promise and the other party performs an act requested by the promise. Many times this causes problems as one making the promise may not know the action is completed, or the length of time to do the action is not defined. It becomes unacceptable. The classical case is I'm sitting on my porch and I see a kid driving by with a lawnmower, and I point to my lawn. And the kid nods his head, gets out of his truck, takes the lawnmower out, and cuts my grass. Well, I made a promise by my action to cut my grass. When he cut the grass, it was a contract. Now, if he just drove away, not a contract. But once he starts doing the work, that makes a contract. That makes the unilateral contract complete. Now, what if I point to the grass and he drives by, and later that afternoon, 4 or 5 hours later, he comes in to do the work? Is it a contract? Did I need to give him immediate response from him, signifying that he was going to do the work and start the work? Or were delay? And of course, that's a question of law. What was the intent? What was required? Is there state law in the area, etc.? Or it might be the situation where I point to my grass and I go in the house, and he cuts the grass. Well, I went in the house, I didn't know he cut the grass. He got back later for money, and I said, what do you mean? I said, I pointed to grass, or he says I pointed to grass, and I said, well, I was just pointing to you. I was trying to be friendly. And he says, well, I thought you wanted to cut the grass. Again, question of facts, which is going to be settled. So unilateral contracts are not as good because things go in the area of case of the timing of it or the actions involved and what is the intent of the parties, etc. And obviously the best type for a planner is the bilateral contract, where I make a promise and my client makes a promise, rather than I make a promise and the client accepts it by doing some action. Both parties must intend to be legally bound, and the issue usually comes up if the document is titled Memorandum of Understanding, Memorandum of Agreement, Letter of Intent and Agreement. And again, I find that in the real world, these are much better words to use than using the word contract when I'm dealing with people, especially because I have a law degree and they see that JD, they're afraid I'm trying to take a legal advantage of them. They feel more comfortable, and we make it very clear in the memorandum that it is agreeing to be a commitment on both parties' parts. And that's the key, where we have it. This is a commitment on both parties to carry out the following. And I have here, this is obvious, a contract should be called on a contract to avoid issues later on. What I'm really talking about there is in the body, not the title. And although if you put it in the title, it's clear, but again, I have had problems with clients in that area. Another point we have here is contract must be stated consideration on the part of all parties. In other words, we have to state what the consideration is. We just can't promise there will be consideration. And I think an interesting thing is that consideration values need not be the same. I could give you something for $1,000 value, and you could give me something worth $100, And if that's the intent of the parties, now we have a contract. Now, whether or not the IRS would agree that that was a contract for that's a fair arm's length transaction, that's another issue. So we're not paying attention to the IRS angles on this, but could a contract be $100 for $1,000? The answer is yes, if that's the intent. And what we mean by the word consideration is not necessarily monetary. It could be taking on a duty, taking on a responsibility, or it could be giving up a right. So giving up a right would be, for example, giving up money or giving up some of my time. And a duty, I think, is quite obvious what that is. It's taking on a responsibility. But either of those could be, and I could take a duty in exchange for giving up a right, or I could have a duty for a duty, or I could have given up a right for giving up a right. Each of those are valid considerations. It should be noted that drastically different values for the consideration may result in the IRS arguing that it's part business and part gift. And I again want to bring that up again once more, because too often people think, well, we have a contract, therefore there's no gift involved. Well, the IRS might consider a gift tax, and that's going to happen at times, especially if there's not an arm's length transaction. And an arm's length transaction is basically put its way two in the parties would react with each other for the benefit of themselves. In other words, it isn't a case where you're dealing with a very close friend you want to help, or a child or a parent. It's how would you act with strangers? Would you do the same? And if you would do the same, that would be called an arm's length transaction. Capacity, both parties must be competent and have legal capacity. And that sounds easy, but let's look at what that means. There are two types of persons, and both can have legal capacity. There's a natural person, being individuals. I think we all are aware that there's other types of persons. For example, a juristic person could be a corporation, a trust, and estates. And they are treated just like individuals as far as contracting. A trust can be involved in a contract as a corporation. Guidance is who has legal capacity, decision-making capacity. Examples are, do they understand the information that's involved? Do they understand the consequences of the decision? Are they acting voluntarily? Is it autonomous? And finally, are they communicating their decisions? And last comment here is reflective capability, being able to assess one situation and future possibilities. These are basically, we're looking for a legal capacity. Now, I didn't bring in here age issues, but there's certainly there's certain rules for people under the age of majority. Again, depends on what state is age of majority for your state. But let's say someone 14, in cases, can sign a contract. For example, when you buy something in a grocery store, that's a contract. So if a child goes into the store at 14 years old and buys a loaf of bread and buys some meat and some vegetables, can the clerk say, well, you don't have authority to buy in here? Well, of course, he has the authority. Now, there's certain rules where the child can get out of this situation, but we're not going to get in here because you're not going to have children under 18 coming in for financial planning. So I don't want you to get bogged down in it, but realize that there's this mental capacity for kids and minors. Likewise, if you have people who've lost mental capacity and they no longer appreciate what they're saying, they forget what they're saying, quite honestly, that's another thing where they don't have the capacity. Formalities in the statute of fraud. When we call statute of fraud, it's a very old term. Today we think of fraud much differently than it is intended here. And really what the statute of fraud is trying to do is prevent fraud by requiring documentation. And let's be blunt. Written contracts are obviously more favorable than oral contracts. When I first became a financial planner, we still had the board not very clear on what type of contracting they expected. Since then, we, of course, come up with the guidance from the board that talks about the written contract and what we're to do in our first steps of the process of dealing with the clients. But when I first got in as a financial planner, there was no mention of the written contract. But it is best over oral. There's no misunderstandings, or drastic reduction misunderstandings might be a better word. We have certain contracts that must be in writing, such as insurance and real estate. And again, that depends on the state laws. I'm not sure if every state requires it, but certainly most states require these two types of contracts to be in writing. Oral contracts can be by word of mouth or by actions of the parties. So the okay sign could be a agreement, just like it would be a sign that you're going ahead with the unilateral contract. That going okay doesn't mean that you're going ahead with a unilateral contract. That's letting the other party know you're going to go ahead. Once you start to work, it becomes a unilateral contract. And some states are still requiring contracts, if over a specified dollar value, to be enforceable, and the number is usually $500. Some more on the formalities. This can be a major issue for practitioners in some states, as clients many times change their minds, and the planner is thus alleged by the client to have verbally changed the contract. And I kind of smell at that, because it's the planner who changed the contract, not what the client changed their mind, that becomes the issue. And you got to learn to put up with that. Suggest that the contracts of clients clearly state that no change of contract is effectively put in writing and signed by both parties. Generally solves that problem, although you'll still have people coming back and saying, well, that isn't really what I intended, or that isn't what you said. And I got to try and go back and say, well, this is what we put in writing, that we both agreed on it. And when we sat down, I said, do you understand what this is? Do you have any questions before we sign? Okay, let's sign. And then I usually send a follow-up letter to them saying, we signed the contract on the whatever date, and again, here's the main issues involved.